All right, we are back into it, and I am excited to introduce David Katz. You know him as a former federal prosecutor, a defense lawyer in Los Angeles, but most recently, a media mogul, as it were. He's been on television, radio, on the internet, everywhere from Los Angeles to New York to London to here on the Mark Thompson Show, where we are lucky enough to have this incredibly brilliant legal mind every week. It's David Katz, everybody. Hey, how are you?
It's great to be with you. It's been an honor to have been invited on for these appearances and all this different media, but I'm not a mogul. I don't own any of the stations or programs.
You're a mogul to me. You're a mogul of your own media appearances. Okay, so let's jump right into it because the Colorado GOP is officially now appealing the Trump ban on the 2024 primary ballot in Colorado to the Supreme Court. Not unexpected, but any thoughts on what may play out during this appeal?
In the Colorado Supreme Court ruling?
Right. They're now appealing it to the Supreme Court.
Yeah, my video is going in and out, but it's not on your show. Thank goodness, right?
Okay.
Good.
Yeah. Okay, you're good.
Good. Well, the Colorado Supreme Court one was the one that was 4-3. It's not affected by the fact that Michigan went the other way. Michigan has a completely different law that its state court was interpreting. So this one really stands on its own, and he was barred from the ballot as an insurrectionist. And the timing is going to be difficult for him actually not to appear on the primary ballot for the Republican nomination in Colorado, because apparently the ballots have to be printed out in early January. But it's understood. I mean, my understanding of the ruling and how I've heard other commentators talk about it, my own legal analysis, is that if the Colorado Supreme Court doesn't hear from the U.S. Supreme Court by January 4th or 5th, that may change things. Everyone's expecting that there'll be a stay of the ruling by the U.S. Supreme Court that will say from January 4th until we decide this case, the Colorado Supreme Court has stayed. Or they might just summarily reverse it. I don't think that's likely. So I think the very most likely thing is that the ballots will go out with Trump's name on them. But there at least is a possibility that this will kick in for the time of the general election. And that even if Trump won the Republican nomination, he'd be barred from appearing on the ballot against Biden in the general election because he was found to be an insurrectionist after having been given a trial in the Colorado trial courts. It's also different from the cases where they say the person hasn't gotten due process, because Trump has, in my judgment, gotten due process in Colorado. He had a trial. He was allowed to put on his defense. All of his rights were observed. And after that trial, the judge decided that, yes, he participated in the insurrection and that the insurrection was of the type that the 14th Amendment mentions. So we'll have to wait and see. But there was certainly a stunning ruling. I don't think it's going to ultimately affect the election, in part because Colorado is a blue state. But certainly it would start a groundswell, I think, of similar rulings, even though the laws are different, Kim, in other states. Because if this happens and the U.S. Supreme Court lets it happen, I think these other states will be emboldened. Their secretaries of state and their attorneys general will be emboldened in blue and purple states and make this kind of a motion with regard to the general election.
So we know the United States Supreme Court has never ruled on Section 3 of the 14th Amendment before. So this is we've never seen anything like this kind of moment. A couple of questions.
There's never been anything like this.
First of all, if there is a Supreme Court Justice David Katz on the bench, what's your ruling? What's your decision on this?
On the Colorado, on the Colorado Supreme Court case?
Yeah.
I know that it sets a bad example for other cases, but I think the insurrection was one of a kind. I think it was unique. I think it was the insurrection that the framers of the 14th Amendment were talking about. It was a marauding of the Capitol with the motive, and I think it was clear from the evidence, with activities done and incitement done by Trump so that the peaceful transfer of power would be impeded. so that there would be a riot instead of a counting of the votes, and that he would stay in office. And I think this goes to the absolute cornerstone of our democracy. We've always had a peaceful transition of power. Even Lincoln had an election during the Civil War, and he was ready, if that was the decision of the voters, to lose. And actually, it was an interesting footnote to history. Lincoln supposedly was going to resign right away and not wait for the 4 or 5 month inauguration period before he left, because he figured if it was the will of the people to stop fighting the Civil War and make peace with the southern states, that so be it. But of course, Lincoln won the election. But my point is that we had it. And this is so fundamental. And I know that it's a very smart thing to worry about other states, red states, trying to throw Biden or other Democrats off the ballot and say that they participated in, the Black Lives Matter demonstrations that went violent. Those amounted to an insurrection. And the simple answer is that try that case. See if giving someone due process, any court is upheld that finds that being soft on Black Lives Matter demonstrations or telling somebody, don't call the cops out, just let the demonstration go on and it turned violent. That is not an insurrection that bars you from the presidential ballot. Trump's was unique. I'd be one of the votes that said he can't appear on the ballot. And Colorado is a state, has a right to make that state decision. And I would deal with the next case where supposedly a red state threw a Democrat off the ballot by seeing, did that Democratic candidate get due process? And if they did, and it really was insurrection, it really was a violation of the 14th Amendment, then the Constitution's clear. And I think the textualists, the originalists, should agree with me, because the language of the 14th Amendment is very clear, except maybe on the issue of, is the president an officer? But that one I think is really absurd if you analysis. The law is not a suicide pact. The law is not an exercise in idiocy. If you come to an absurd result, that's probably not what the law really intended or what the writers of the law intended. How can the most powerful office in the federal government be the one office in the federal government that's not covered? How can the president not be an officer of the United States? Why is he getting Secret Service protection? Why is he living in this house that we finance if he's not an officer of the United States?
So I don't know if this is a stupid legal question or not, but I know when the Supreme Court makes a ruling, it's the law of the land. And so if they rule that Trump cannot be on the primary ballot in Colorado, or if, as you say, maybe it's just the primary ballot is coming too soon, so it's the actual ballot, for president. Does then, if they rule that he can't be on it, does it become, could you interpret the law of the land in all states, so that then could it be that he's not allowed on any ballot in any state, or is it still a state by state issue?
Our elections, even for president, are state by state. Mm-hmm. And each state has its own peculiar, some maybe idiosyncratic rules for getting on the ballot and challenging how a person is allowed to get on or stay on the ballot. And so really the Colorado law, because Colorado has its own unique laws, really wouldn't affect anything else in terms of whether it was due process under the laws of that state and the ultimate ruling. What I'm saying is just that it would encourage, if that was the result, that there was going to be a general election for president in Colorado without Trump's name on the ballot, the pressure on attorneys general in other states, especially in blue states and purple states, would be overwhelming. Why haven't you made those motions? Why haven't you pursued this more vigorously? And the lawyers would pursue it very vigorously to try to get Trump taken off the ballot on similar arguments, but they couldn't say Colorado did this. The U.S. Supreme Court is only going to affirm or not affirm or leave alone the ruling of a state. It's unusual that a state's rulings go up to the U.S. Supreme Court at all. Yeah. And it has to be argued that there's some federal question. A state can do what a state wants to do unless it violates a federal law or the federal constitution. And so people need to bear that in mind, because it's so easy the way we drive across states. We have so much interstate commerce that we are still a collection of 50 states. The idea was, we're different countries, almost like, Spain and Germany and Austria before they all joined the economic union. Well, we joined ours, and of course, we have much closer bindings between the states than that Federalist European Union does, right? we ended up binding much more together and being much more, in some ways, homogenous. But each state is, as they say, an experiment for what that state wants to do. And unless they're violating a federal law or the federal constitution, states can do what they want to do.
Let's move to, well, we're still talking about the January 6th, but Jack Smith, the special counsel, is trying to exclude what he calls baseless Trump claims and conspiracies from the January 6th trial. His quote is, "A bank robber can't defend himself by blaming the bank's security guard for failing to stop him." And so he doesn't want all these baseless things that Trump is saying, blaming political persecution, all these ridiculous things. He doesn't want them included. He's filed a motion to keep Trump from sharing these claims and conspiracies with the jury in his election trial. Does this go anywhere?
Yes, this will go somewhere, because it's the obligation of the district judge in a federal case to make sure that justice is done according to the law. And part of the law is that you can't have arguments that don't go to the elements. There's elements of the offenses, and you have to prove, if you're the prosecutor, beyond a reasonable doubt, all the elements of the offense. And the defense can challenge anything that logically, relevantly goes to the defenses. But they can't just give a political speech. A lot of the stuff that Trump sends out is just junk. So let's take an example of they didn't defend the Capitol enough. Okay. They should have had more people. Maybe some of the people there were really Antifa. If he's got evidence that some people were Antifa, if he wants to call someone to the stand to say they were Antifa, or if he can present non-hearsay relevant evidence that somebody was Antifa, but just to make a broad argument not based in fact, like, oh, there were so many Antifa people. No, you can't say that if you don't have evidence to support that. And it's improper to make an opening statement that suggests that if the lawyer doesn't have evidence that's going to back it up. And it's improper to make a closing argument where you say, we proved that these were all Antifa people, and that if Pelosi had sent more people, that would have quelled the riot. That's ridiculous. First of all, Pelosi didn't control the entire House and Senate. There was a Republican who controlled the Senate. What is it, McConnell? And there are all sorts of procedures how to get people there. That's not what this trial is about. This trial is about whether Trump incited it, right? Whether he did the other things that led up to it. The slates, come to Washington, it'll be wild. All the other things that he did. It's not a trial about, did somebody post, more people. Now, if there's a particular issue about posting somebody, you see what I mean? If it's a particular factual or legal issue, that's really relevant. But the kind of just general, broad brush, no evidence behind them. This is how I feel. This is the way I think the world is. It's full of conspiracies against me by Trump. This is properly kept out of this federal trial.
Let's move to, we mentioned it earlier, the Michigan Supreme Court. They are rejecting the insurrectionist ban case, and they're keeping Trump on their ballot, unlike Colorado, their primary ballot. And one of the reasons is because they said the state law doesn't give election officials any leeway to police the eligibility of presidential primary candidates. So in this case, they kicked it out because they couldn't figure out who is the person that makes the decision as to whether or not someone was involved in the insurrection. And so how would we know? So we're just going to put them on the ballot. Is that correct?
Well, I think it's more that they're saying that they don't have to reach this issue until they get to the general election. That you can run for the Republican nomination or the Democratic nomination, even though you were an insurrectionist barred by the 14th Amendment, even though you're only 22 years old, even though you're not native born in the United States. You can put such a person on there. And then if that person ends up winning and they want to be on the general election ballot, then there's an issue. Wait, can they be on the general election ballot? So I think all that Michigan said is they're not going to reach that issue until it's the general election ballot, because these are not qualifications to run in a primary. Okay, that's Michigan law as interpreted by their Supreme Court.
Okay, so I'm glad I asked, because I was reading that differently, so I'm glad you clarified. There's a story also today about state officials talking to the Supreme Court. They want to be allowed to continue conversations with social media companies. So this is a case where it involves Facebook, Google, other social media platforms about concerns over content. California is one of several states that are urging the Supreme Court to allow them to communicate with these companies on the best practices to protect minors against online predators and everything else. Why wouldn't the states be allowed to communicate with the companies?
Kim, I got to tell you, I'm just not that familiar with that
Okay.
case. So maybe we'll talk about that next week. Would that be
All right.
okay?
Yeah, we'll move on. How about this case then? Let me throw this one at you. The New York Times is suing Microsoft over the use of their material with Chat GPT. They say, listen, Microsoft, you don't have permission to feed our articles into your Chat GPT system and allow the Chat GPT to then regurgitate everything. So the New York Times is suing Microsoft over this whole issue.
Well, it seems to me that this is going to depend on, a copyright law, that sort of thing. As the New York Times does have a copyright, there's certain fair use, like a quotation out of the New York Times. You wouldn't think feeding the entire New York Times to become the artificial intelligence of these bots would be a fair use. Just kind of as it hits me, that seems like that's something that Microsoft would have to pay them for. And maybe there's some price that the New York Times would accept, but zero, which is apparently what they've gotten so far, bupkis, is not the price. So I think that one will go off on fairly technical issues, but in a way, it's an affirmation of the accuracy of the New York Times. What does Trump call it? The failing New York Times. I mean, I read the New York Times like I do everything else,
Yeah.
with I always question everything, always ask, what about this, what about that, why aren't they covering this as much? But I think the New York Times obviously is just a fine newspaper.
Yeah. There's a story out of San Francisco. I don't know if you've been following this, but I'm kind of fascinated by it. San Francisco is going to try to levy a tax on the owners of homes that are sitting vacant and empty. They want homes to be rented out. They've got a housing shortage, and apparently there are thousands of homes that are just sitting unoccupied in San Francisco. So this tax was approved last year by San Francisco voters on these thousands of vacant homes, but now there's a legal challenge by real estate groups. A judge declined to dismiss their lawsuit, so the empty homes tax is under a legal challenge now.
Well, it's not individual homes. So if you have a summer place in San Francisco, and that's basically what it is, and you're only there a month of the year, this is not going to tax you if you don't rent it out or make you rent it out. I think this is just 3 or more units, something like that.
Okay.
I see where the city is coming from. The city of San Francisco wants to have more housing and more affordable housing. And if, some company is, and I guess you can imagine a situation like this, Kim, they could rent pick any number. They could rent the unit out for $3,000 a month, but they'd really like to get $4,000 a month. So they'll keep it vacant until they can get closer to $4,000 a month. If the tax is $2,000, they have an incentive to just rent it out at $3,000, not to wait around to try to get $4,000. And so they would accept a lower rent rather than pay the tax. And so it will, from the landlord's point of view, it has to do with their this is the classic issue that we've always had when you have government regulation, that the government regulation tends to affect supply and demand in a way that affects price. And then whether you're the guy who owns the wheat, whether you're the guy who doesn't want to pay workers as much, whether you're the guy who wants to get more for your property by leaving it vacant and see if you can bring in more of a market price, you don't like the regulation because, right, it sets a minimum wage, it has a price support or a price check on wheat, or like in this situation, it makes it disadvantageous to not take a somewhat lower price and get the place rented rather than pay the tax. So we'll see how it comes out. I see why the judge didn't dismiss it. And I think it's going to depend on, this idea of takings. You can pretty much diminish the value of property. You can't reduce it to zero. Maybe you can't cut it in half, but you can certainly reduce the value of property by regulation. Did this one go too far or not? We'll see what the judge ultimately rules.
A new ruling just came out, and I didn't email you this one, but this as a federal judge that today has decided to uphold the Republican-drawn Georgia congressional map that safeguards the Republican dominance in the state of Georgia. This has been going back and forth for a while. The court says the General Assembly fully complied with the court order requiring the creation of a Black majority district in the regions of the state where vote dilution was found. So the court overrules the plaintiff's objections. This is the ruling from U.S. District Judge Steve Jones. In October, he ordered the Georgia General Assembly to draw new congressional and state legislative maps after the 2020 census, saying the state legislators improperly diluted the political power of Black voters. So here's a ruling coming out today that everything's okay and the Republicans can basically stay in power.
So this is a ruling by the appellate court that overturned the trial judge. Is that what you're saying? I'm not. As I say, when you spring these ones on me,
no, at the last moment. I know it's a federal judge that it looks like the same judge in October told the Georgia Assembly, you can't do that. And so they made some changes, came back, and it still safeguards the Republican dominance in Georgia. But now he's saying it's okay. So.
Well, if there were particular issues that the judge raised and the legislature addressed them, then I guess it got approved. I mean, this case will probably go to the Court of Appeals, but it's conservative down there. That's the 11th Circuit Court of Appeals. Yeah. By the way, I just did want to mention one thing about the 11th Circuit Court of Appeals, because we've kind of been watching the former White House Chief of Staff, Mark Meadows. Remember, we've been watching that he claims that he shouldn't be prosecuted in the state courts of Georgia by Fani Willis, that he has a right, unlike the other defendants, to go to the federal court because everything he did was in the course and scope of his federal duties when he went down there to Georgia. They obviously there's two different views of what he went down there to Georgia to do, but the criminal view is that he went down there to tamper with the vote count and to interfere with a proper count of the vote in Georgia, when it was clear, by the way, at that time that Trump had lost and he'd lost the recount. He said he had a right to go to federal court because everything he did was in the course of his official duties. And the 11th Circuit conservative judges said, no, you have to go to the state court. And why that ruling is important, and again, it doesn't bind the Supreme Court, but it's important because, that's what Trump is really arguing with presidential immunity. He's arguing everything that he did that's being charged in D.C. federal court against him. Everything he did was in the course and scope of being the president. And of course, the answer to that, and the reason why I think that the U.S. Supreme Court is going to reject this presidential immunity argument, or the D.C. Circuit will reject it and then the Supreme Court won't take it, is because what Trump is charged with is not within the course and scope of his duties. Think about it. There should be, even in my judgment, presidential immunity for if you decide to make peace with a foreign country or not. That's in the course and scope of your duties, okay? Right. And if people said, well, we shouldn't have made a deal with Israel, it really turned out terribly. Look how Netanyahu went so far to the right with the settlers. Look at all the terrible things that have happened since. That was a president's decision-making. Even if it was a rotten decision in the view of history, it was a president's decision. A president does have immunity, even once he or she has left office, to be prosecuted for that. But what Trump is charged with in D.C., all the way up to the insurrection itself on January 6th, the speeches that he gave, as I said before, the slates, the trying to jump Department of Justice official over all the others so he would sign a letter that it sure looked was like made phony claims. All of those were not things that were done in the course and scope. And Meadows illustrates that things done right up to the January 6th insurrection and right around then by these top officials in the White House. Here, the 11th Circuit saying, no, what you did was not in the course and scope. As a matter of law, what you did was not in the course and scope so that you have a right to be in federal court. At least you haven't shown that to us. And I think that's going to be what Trump's situation is, that when he's not going to be able to show, he wasn't able to show to the district judge that what he did was in the course and scope of his duties. It looked like it was what we call ultra vires. It was beyond the scope, beyond the pale. It was criminal conduct. And I gave the example the other day. It can't possibly be that you have presidential immunity for just crimes in general, for things that were not in the course and scope of your duty. Otherwise, one president could hit or even shoot the other president and say, I had immunity. I shot my rival for the office and I can't do anything about it because shooting your rivals not in the course and scope. And in my judgment, what Trump did and what he's being prosecuted for is not in the course and scope. And he tries to make this whole big jumble about it, and it just doesn't work except with his base, unfortunately.
But the Supreme Court says that has to go through the lower court rulings before this issue will get to them. Why don't they just come out and say what you just said?
Well, first of all, we do have a system, and the system is that you go to the appellate courts before you go to the U.S. Supreme Court. And the appellate court in this case is moving it very fast. It was very frustrating and irksome when we watched you, me, and Pat Thurston as we were watching all these cases when Trump was president. And, it took 2 years and 2 rounds of going to the Supreme Court even to get the tax records from Trump. And so we saw those very, very long delays. But this is not one of those where Trump just kicks the ball, kicks the can down the road, and it seems like time goes on forever. They're going to decide that. They're going to have an argument, I think, January 8th or 9th. The D.C. Circuit is going to have received the briefs and have an argument by January 9th. They could decide the case January 10th or 11th. Yeah. And at that point, it can go to the Supreme Court. The Supreme Court will either take it then or not take it. But it shows signs of moving to the U.S. Supreme Court so quickly that I think it does. It's certainly arguable that the Supreme Court does not take cases directly out of the trial court and decide them boom like that. There was the famous U.S. Steel case during the Truman days. I think one of the Watergate cases. There are exceptional cases like that, but this case is moving plenty fast, Kim, without the U.S. Supreme Court jumping over the appellate level.
Have you been paying attention to the nominees that President Biden has put forth in the courts? Because I was reading this article yesterday about how the bench is really being affected by diversity, that the historic numbers of women, people of color, public defenders on the federal bench have increased over President Biden.
Well, I had the privilege to be a law clerk to a African-American judge. He was young, he was diverse, he was appointed by President Carter in 1979, and then I clerked for him almost right off the bat, like from 80 to the end of 81. And so having worked with a judge who was so diverse, and then in the same courthouse, we used to see Justice Ginsburg before she was a justice when she was on the Court of Appeals. They were actually friends. She came to the unveiling of his portrait, things like that. So you look at two people who were very diverse, fairly young when they were put on the bench, and both of them were terrific. So I think, and you look at the justice that Biden put on the U.S. Supreme Court, Jackson, I think, she's been terrific. And just talking about other people who've been diverse, I mean, Kagan has seemed to be a tremendous justice. And so has Sotomayor, the first Latino Hispanic justice on the Supreme Court. So, my feeling is, that he's picked some really good people, and I don't have a problem. And he ran on those issues. He made it clear that he was going to appoint a diverse bench, and he did beat Trump by 7 million votes. The Electoral College has all these peculiarities. And we have these purple states. But remember, he won by over 7 million votes. So his agenda was popular. And I think people need to take a second look at Biden. I know he's not, young and vigorous, but look at the record. Look at what he's actually done. Look at the state of the economy. I think they're taking steps even right now about the border. They're down there speaking. Top officials from the White House are down there. The head of DHS, my old friend Ali Mayorkas, they're down there talking to the Mexican government. And obviously there needs to be a lot of diplomatic work, right, with the Mexican government to deal with this problem, because the people are coming. The huge problem is not people flying into airports and overstaying. The huge problem is people crossing this 2,000-mile border with Mexico and then being paroled into the United States. And that latter thing is debatable. And the amnesty threshold is debatable. And Biden has said he wants to work with the Republicans in Congress. So let's see if they want to work back with him and solve some of these problems, or whether they just want to, demagogue this issue and have Fox keep pointing its cameras at the border.
Yeah. David Katz, any big New Year's plans for you?
Well, I'm planning to spend, I was planning to spend the New Year right now. I'm in New York, actually. And I'm planning to be in New York a bit longer. and then I'll be in sunny Southern California. And I have cases all around the country. I just got hired at a case, it looks like, in one of the southern states. So I've been to 38 different states, and maybe I'll go to 39 or 40 this year, depending. And how about your New Year's plans?
Oh, pretty quiet. We watch the ball drop on TV and have champagne on our couch. We're really exciting over here. Woohoo!
Well, that's lovely. And it's been great being with you. And I wish you all the best in the new year. You, Mark, all the crew there. I know you have different people on some days, so I don't want to say the wrong name. Who do you have with you today?
It's Albert today. Mm-hmm.
Albert, Happy New Year. And Happy New Year to all of your viewers. And it's been great to be with you this year.
Yeah, Happy New Year to you, and good luck with all your cases. And we'll see you in 2024.
Can't wait. Can't wait.
Thank you. David Katz, everybody. That's at David Katz Law. You'll find him there, and you'll find him on your TV screen, likely. He's all over the place. Again, I'm telling you, he's on New York media. He's in London on television and on radio there. Los Angeles, here on the Mark Thompson Show. He's everywhere. So Katzadamus continues his reign. Thank you to David Katz for being on the Mark Thompson Show.
Hi, it's Mark, and I thought that was great. Hit the notification bell, you'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.